Sure, go ahead.
I just thought this would be a good opportunity to let you know that there's a guy named Glenn Bradley. I don't know if some of you know about him. He was a legislature in the North Carolina House up until the end of this last session. He's got a couple really good bills that he's going to try to get in there this session. One of them is called the Firearms Freedom Act, and I think there's a couple other states that are looking at this and passed it. But using the 10th Amendment and the Commerce Clause, they're saying any weapon, firearm made, sold, and maintained in North Carolina or whatever state you live in that does not cross the state lines and is outside of the Commerce Clause and therefore outside of the jurisdiction of the federal government. So I hope that bill gets in there, this legislature, and hopefully it'll get passed. Glenn Bradley, Representative Glenn Bradley. When they redistrict the district, literally his district disappears. Yeah, because he's anti-establishment.
My question is, who's he has policies over there?
There's a few people that can do it. I don't want to name names prematurely.
But my question is, does he have somebody who set this stuff up?
You can ask him.
He does?
I'm sure. I would imagine he's got a couple people in mind.
Okay, just wondering.
Do you know what those bill numbers are?
No, I don't.
They don't exist yet.
They haven't been introduced yet. He's got that one and the Farmers Freedom Act.
You jump in when you can.
Can we use offer this as a possible topic for debate? I disagree with you. I'd like to see that bill defeated. And the reason I want to see that bill defeated is because once you start working under the federal definition of interstate commerce, there's no stopping what they can do. And once you submit a bill like that, you have accepted their definition of interstate commerce, which I do not accept. And I think the Second Amendment says shall not be infringed. It doesn't say shall not be infringed within a state. And once you start to succumb to their definitions, there's no stopping. They just keep getting you smaller, smaller, and smaller.
They're progressives. They're not revolutionaries. They do it piecemeal one at a time.
One does at a time.
Sorry.
Any comments about that from a constitutional law perspective?
Well, I think, based on the supremacy clause of the federal constitution, it is difficult to, to pass a law saying, in this case, I see what the aim of the bill is saying, this is your definition, and we're within this definition, we do not come under interstate commerce. Ultimately, it's up to the federal courts to decide how they're going to interpret these things because they have the supremacy clause at their back. So, sure.
I'm wondering if there is a balance. That law could, in fact, help local manufacturers and local citizens of North Carolina to ensure that we do, in fact, have provision for exercising the Second Amendment rights under the federal Constitution. But
As we fight.
as we fight on, because I saw a recommendation
Well, if the feds were to establish a task force to enforce some sort of federal law, then it would be difficult, absent armed conflict, for the state authorities to oppose that sort of thing. But
Sorry, actually, I believe under that, unless there is an amendment passed to the United States Constitution, the federal government has no legal right to establish a federal law infringing on the Second Amendment right.
well, I think I would agree with that. The problem is, under our system, the Supreme Court, the U.S. Supreme Court, is the final arbiter of what that means. So, I think up to...
If we listen to what the Supreme Court has said, that's not what it says in our Constitution.
Well,
The Supreme Court has no right to interpret the Constitution. The Supreme Court only has a right to verify whether laws are or are not constitutional.
McCullough versus Maryland, or Murray versus Madison.
Well, then wouldn't the federal government, Congress have to tell the Supreme Court you were wrong?
The states should tell the Supreme Court they're wrong.
Yes, the states can tell the Supreme Court they're wrong. 2/3 of the House, 2/3 of the Senate, 3/4 of the states. That's what has to happen for that to happen legally. Now, if we decide to lay down and allow the federal government to act outside of the bonds of the Constitution, that's on us.
But haven't we already done that? Haven't they overstepped their bounds?
Oh, yeah.
Take laws
That's why
and
we were-
recess some movements?
Well, that's why we're going to have a lot of records now. That's my question to you. Is it based on your familiarity with the North Carolina Constitution and our structure here in this state, do we in fact have a means whereby within our state, and if so, what might they be, to overrule whatever the federal government might put forward?
Well, this might be a good moment to maybe clarify some things, but the state constitution protects us from the state government. So, just like the federal constitution protects us from the federal government, and in some ways from our states as well. But so the Constitution is not going to, the state constitution is not going to be a source for throwing things back at the feds, because the state constitution is for state government, and it protects us from state government. I don't know if that's... Sure.
Then, or in your opinion, how does jury notification factor in? Because isn't that kind of like how the sheriff is the ultimate arbiter on the county level, that a juror can knock out state, federal, any kind of law? Would that be a way? Because when they argue between the Montana ban versus, don't do that because they're agreeing to their language, that comes down to whatever the judge overseeing it. It usually goes to federal. They've got the ball in their court, but the jury notification, isn't that kind of like the ultimate weapon against all that?
Right, it may be. I don't know if everyone's familiar with jury nullification, but it's, if you're in court, you've got a jury, and maybe the law says X, Y, and Z, but the jury thinks the law is wrong, and so they just say not guilty, regardless of what the law says. That's a possibility that might come up, but I would say, I don't know if I would trust that. If it was my life on the line, I would not want to my life and liberty on the line, I would be afraid to trust jurors to do that sort of thing. But it has happened before. So.
Well, the fact that you only have to sway one juror out of 12, or just sway one person, so it's easier to sway one out of 12 than just one.
No.
Along those lines, is it, I used to live in Georgia. I know that Georgia state constitution, they actually incorporated jury nullification. I said juries are judges over both fact and law. Does the North Carolina Constitution have anything like that?
To my knowledge, it doesn't have that. There is a right to a jury trial under certain circumstances, but in North Carolina, and I think probably most states, if not all but Georgia, the judge is going to determine the law, and the jury is going to determine the facts. But. Okay, I don't know how they do it down there. Sure.
Question what the gentleman said, though. I mean, all you have to have is one juror. That's a hung juror, and the prosecutor can decide to prosecute again. If you're declared not guilty, double jeopardy applies. You can't be re-prosecuted.
That's correct, yeah.
So, and
you know, I know there have been lots of debating recently about nullification and things of that nature. You know, one thing I will say is that I think there are some causes for hope, and I know Bill's going to talk about the federal Constitution in a few minutes, but you know, the Supreme Court today, the U.S. Supreme Court, there's at least a majority at this point that supports gun rights, at least generally. And there have been a couple of recent cases, in Washington, D.C., where they declared that Washington, D.C.'s ban on possession of firearms was illegal. And they also, in Chicago, they incorporated the Second Amendment against the states. And so pretty much it's the feds, the Supreme Court has said, government, you cannot ban guns. So that's been established, I think, fairly clearly. And then there's been some lower court decisions very recently that have bolstered the right to carry, to conceal carry. So in Illinois, while they can't ban guns, they still have, up until now, a ban on carrying any kind of firearm, even concealed carry. I think they're one of maybe the only state that has a complete ban and no provision for concealed carry. But the federal Seventh Circuit said a couple weeks ago that they have to have some provision for concealed carry. So there are some glimmers of hope, at least on that issue.
What is the North Carolina Constitution? It's got something in there about concealed carry under that right to keep a bear on.
Right. Well, actually, the state constitution says that you have the right to keep and bear arms, but it does say that that doesn't prohibit the state from banning carrying concealed weapons. So the state constitution basically says nothing about concealed carry or things like that. But obviously, it's in state law, and to be honest, I don't see that changing under state law anytime soon. Yeah, I can. It looks like it's shut down here, but I think we're running low on battery here, maybe. But I think what you're referring to is the bail bonding agents associations. There's two rival bail bonding associations, and one of the bail bonding associations, they do continuing education for bail bondsmen. They got the legislature to pass basically a monopoly for them, which would make it illegal for their competitor to operate. And the people that were put out of business, they challenged us in court, and for the time being, Wake County Superior Judge has said that's unconstitutional, and you can't prohibit them from operating. And this is because of a provision in our state constitution which bans monopolies. Now, you know, the courts kind of get squirrely on this one sometimes, and they allow certain monopolies, things like utilities and things like that. So, you know, they get kind of squishy there, but in this case, this provision has been used to try to push back on that sort of thing.
When was that rule? Because I just read the article that it bothered me with one senator, even though he recused himself, he's basically the primary party of the one that got the other one prohibited.
Right. And I believe that this ruling came down maybe a month or maybe a little more ago. So, you know, I don't know about the article specifically, but I think that's when the ruling came down. It's been several weeks.
Because it was quite an extensive article, didn't speak too well of the senator.
Yeah. Well,
It's a very important position in our Senate.
right.
It would be Tom Appodoc, he's the chairman of the Rules Committee of the Senate. He's from Henderson area, right? Where's my friend from Henderson? Yeah, yeah. It's a very informative article.
about done. If you have more questions, we can take a few more questions. We've got a couple minutes. But this is our address. Our website is on here. If you want to sign up for our newsletter, we have a monthly newsletter. You can go there and do that. Check us out. We've got white papers where we basically produce legal opinions, like 2 or 3 pages on specific issues as they come up and things like that. You know, we're 501c3, so tax deductible donations are appreciated too. But so that's our little spiel there. But and by the way, take constitutions. They're back here. Everyone take one. And there's pamphlets about our organization. You can take those as well. And there's a sign-up sheet. I don't know if anyone has yet, but you can put your email address on there if you want, or you can go to the website and do that. But sure. Yeah, sure. We'd be glad to do that. Absolutely. Yeah.
When the constitutions were rewritten rather than revised, were there things that were lost in translation? In the process?
I don't know specifically the answer to that question, but I think in general they really borrowed heavily from times before, and I think they tried to fix what they thought was wrong at the time, like for instance the property qualifications for voting and things like that. So I think they just tried to fix what was bad and keep what was good.
So that word like emoluments in there.
Yeah, that's actually part of the monopolies clause. Yeah. So I couldn't define that for you. I kind of know generally what it is, but that's an old word there, right?
What does it mean?
It means like special privileges that the government might give. So, yeah.
How does the state define monopoly?
There's actually about 4 factors that the courts have used to determine what a monopoly is. I don't know if I'm going to be able to name all 4 off the top of my head, but basically control of a market such that you can control a price and also excluding other competitors from that market. And there may be one other factor there that I'm leaving out, but that's basically the gist of it. The courts will sometimes allow a monopoly if they feel like it's, this service is needed, but it's not being provided by anyone else. I don't agree with that, but that might be one possibility. That hurts. Yeah. Yeah. Sure.
Sir, I'd like to take back to what you said about the, I think you said the 1990 gun ban, federal gun ban in schools, that you said the Constitution, the Supreme Court ruled as unconstitutional. That being the case, how are they still enforcing the gun ban on schools?
Well, I'm not sure about a federal gun ban in schools.
Yeah, they just rewrote the law in '96.
They rewrote it.
Yeah, so they took into account what the Supreme Court had said.
Yeah, and I don't know that that's been enforced, but
It hasn't been challenged again.
right. But I will say that under state law, it's illegal anyway. So you would need to change that before you could get to changing the other. But
I've heard that in the recent school shootings.
right. Right. Yes.
The Supreme Court struck down the 1,000-foot exclusion zone. They were trying to exclude guns 1,000 feet outside the school properties. So that was what was struck down, from what I understand.
But then the Congress passed the same law again, and they added findings to the law, which is an explanation of why this was not a violation of the Congress clause. And it stands, it hasn't been challenged again. But it is unconstitutional in the legal law, because Congress has no power to pass the law like that.
All right. One more. Yeah.
You or other people that are on the staff of the Institute are available for consultation with or without an appropriate donation?
Yeah. That is donation is not required. We don't actually, in our clients, we don't accept any money from our clients. But yeah, if you've got like an issue in your community and things like that, we'd be glad to hear about it. We actually have a submission form on our website. That's the way we would prefer to get issues like that through the website. and you can go there and tell us what's going on, and we'll get back to you and tell you what we think. And if it's something that we can't get involved in or don't normally do that particular aspect, then we'll let you know that too. But yeah.
Is the Institute looking to be involved with the fight against gender?
That is something that we've not been involved with yet, and so I don't really know. Yeah, and I don't have a crystal ball, so I don't know. I'm not sure. That's above my pay grade. So well, I appreciate you guys. Oh, do we have one more? Sorry.
I have two. One that just came to my mind. In the Article 5, 6, Section 2, qualifications of a voter, it said any person who is a resident in the state of North Carolina for 1 year is eligible to vote. We do not do that.
You mean?
That's still on the statute, that they have to be a resident in North Carolina before we allow them to register to vote?
Legally, yes.
I mean, as far as I know, that is a requirement.
For 1 year, for 1 whole year before you can register to vote.
I mean, I don't know that anyone, is this a particular issue that has been, because I'm not aware of that,
We
but,
have college students that come and they only
Right.
live here for a short time, but because they live in Forsyth County, they're allowed to vote in our election.
They've
But it does say
actually
that the
played
General
for
Assembly
elections,
can change the rules of residency for presidential elections, which I could understand if they might be allowed to go to presidential, but maybe not in our
There's
county
no
elections,
such thing as
because
a
they can
federal election.
change everything. And what?
There's no such thing as a federal election. All elections are state operations. There just happen to be some that have federal offices on the ballot.
And I think the answer to your question is the fact that one of the benefits of having a Republican governor is we will now have 2 out of 3 members of every board of elections will be Republican. And we may actually see this law rule enforced and hopefully prosecuted.
sure. One,
North Carolina Assembly somehow has the rights to change the way a county runs their elections. They changed the county school board 4 years ago from a partisan election to a nonpartisan election, and then the Democrats made them change it back to the partisan because they all lost. How do they have that right to do that?
well, I don't know about that particular issue, but I know the state, the state government, or actually local governments are creatures of the state in North Carolina. So they can only operate when they have enabling legislation from the state. And so that is probably what was at issue there. And I don't know the particulars.
That would have to be started by your local legislative delegation has to actually file a paperwork that comes with local option legislation vote. Local option legislative vote. But we're getting ready to take our school board elections hopefully back to partisan elections. I've been thinking about it.
All right, well, I appreciate you guys. I love the questions. Thank you for having us.